All right, ladies and gentlemen, welcome to our brand new series, You Be the Judge. So let me share a little bit about the objective of this series. We just ran a 6-week course called Decoding the Talmud, where we explored the making, the substance, and the legacy of the Talmud, and we explored some Talmudic sugyas as well, some Talmudic passages. But one of the things that I kind of wished to do, that I really wanted to do, that wasn't really part of the course, was to take modern cases and kind of go through Talmudic teachings to try to arrive at some sense, some sort of structure with which to approach the cases. And so we have this course here, You Be the Judge, where we have a lot of new cases that are really right now fresh in front of the courts. And the goal is to explore not only our own personal sensibilities about these cases, but perhaps most importantly, to explore what Jewish law has to say about this, or what Jewish law might say about this, given that Jewish law, talks about what it talks about, and sometimes we need to apply the teachings and the principles to modern cases that might be a little different. So we have 3 lessons in this series. In our first lesson, we're going to talk about the laws regarding finding and keeping. We all know the famous phrase, finders, keepers, losers, weepers. The question is, does that actually fly in the law? Just because you found something, or just because you have possession of something, does that make it yours? When does it become yours, etc.? We're going to explore a case that was just ruled on by the Supreme Court last Monday, so about 8-9 days ago. A case of looted Holocaust art. I have separate handouts for that, which I'll pass around in a moment. So that is today's class. We're going to talk next week, in lesson number 2, we'll talk about the laws regarding saving a life, but causing property damage in the course of saving a life. So is there liability? You did a good deed, right? A good Samaritan. You get a medal, perhaps, of honor, but at the same time, And you get a lawsuit. And you get a bill in the mail. You get a lawsuit. The question is, how does that work? And then the third lesson is going to be about burden of proof, or burdens of proof. In Jewish law versus secular, what are the burdens of proof? What are the standards by which a reality must be proven or may be proven? That will be lesson number 3. So we have civil cases, criminal cases. If you like true crime, if you like legal exploration, if you like Talmud study, if you like tracing ancient teachings back to modern or forward to modern cases, if you like the process of debate, analysis, and conclusion, if you have always wanted to be a judge, I hope you all brought your gavels. I didn't bring any gavels. But you do. You have one with you? Oh, okay. All right. Well, so if any of this resonates with you, then you will absolutely love this course. You are in for a treat. All right, so what we're going to do today is, again, today's topic is finders, keepers, and we're going to look at the case. Let's begin with the case study, the case that has come before the courts. It's a multi-decade legal battle, and it's really come to a head very recently. So I'm going to pass these around. So you guys take these 2. And Larry, if you don't mind, please take a pass across and back. And you guys, Mark, please take and pass. Okay, so what I'm passing around now, these are new handouts. You do not have them in front of you. This will form, this will form the opening case study, and it is the most modern case study. I can't imagine a more timely case study than the one that has literally come before the court. So I'm going to read this. It's a little bit long. I decided to quote the entire New York Times article. This article was published on the 14th of March 2025, which is 5 days ago. So here we go. I'll read the title, the subtitle, and the article. Supreme Court revives long-running Nazi art restitution case. The case involving a Pissarro is being sent back to federal court in California for review in light of a new state law and a dispute between heirs and a Spanish museum. So that kind of gives you a sense of what this case is about. Okay, one of the longest-running Nazi restitution cases, fiercely debated within the courts for 2 decades, seemed to have met its end last year when the U.S. Court of Appeals for the Ninth Circuit in California ruled against the plaintiffs. But on Monday, the Supreme Court revived it, vacating the 2024 ruling and remanding the case to the appeals court for further consideration after a California law was passed in September. So far, we're putting this, it's kind of working its way backwards. That's often how news articles are written. You kind of like, right, you start at the end and then we're working back. At issue is the rightful ownership of a French Impressionist painting that originally belonged to a German Jew and was seized by the Nazis. The painting by Camille Pissarro, titled Rue Saint-Honor après midi, Effet de pluie, I don't know if I pronounced that correctly, which is Rue Saint-Honor in the afternoon effect of rain, is estimated to be worth millions of dollars and hangs in a museum in Madrid. So let me pause here for a moment. I've seen estimates that put into tens of millions of dollars, not just millions, but tens of millions. It is an extremely valuable painting, and it's hanging in the National Museum in Madrid. The descendants of the painting's original owner have sued the museum, claiming that the painting should return to their family. One of the key points before the courts has been the question of whether U.S. or Spanish law applies. Interesting, by the way, that that's what's at stake here, right? Which jurisdiction handles this case? The heirs are in the U.S., the painting is in Spain. All right, so that's one of the core questions. Let's continue. Last year, the federal court ruled that Spanish law, not California law, applied to the case and that the museum should retain ownership since it had lawfully acquired the painting. Now, let me just explain that for a second because there's a lot that's missing from this article. So here's the law in Spain. In Spain, it basically goes like this. If you bought something and you did not have any expectation or pretense or awareness that it was stolen, looted, etc. If you bought it under, let's say, good circumstances or honorable circumstances as far as you're concerned, right? And number one. And number two, X number of years have passed since any nefarious activity happened, the looting, the theft, etc. And you have possession of said piece, etc., based on all of these factors. So you bought it in good faith. It's been a while since anything of bad faith happened. So in Spain, that means that it does not go back. It's not returned to original owners or heirs or whatever. So that is what Spanish law says. And the U.S. federal court last year in 2024 ruled that in this situation, we have to defer to Spanish law. They're going to keep it in Madrid, and that's how it ended. Let's continue. Last year, the federal... Did we finish that paragraph?
You're on the last.
Last year? Where am I? That decision. Here we go. That decision seemed to doom the suit until California lawmakers enacted legislation in response to the court's ruling. The new law, which was passed in September, which, by the way, is after the appeals court ruled on it, so California passed the law, says that artworks stolen by the Nazis and artworks in other restitution cases should be returned to their original owners. So that's a brand new California law that was crafted and passed in September, specifically in response to this case. The painting at stake was originally owned by a Jewish woman, Lily Kassirer, who had to surrender the painting to the Nazis in exchange for an exit visa from Germany in 1939. So she did exchange it for an exit visa, so she got something in return, but we might as well consider that to be forced, stolen, looted, whatever. Sorry?
But she's alive.
She's not alive.
But she wasn't.
She was alive.
Right.
Correct. When it was taken from her, correct. The painting was later sold at a Nazi government auction. Those are words that you don't usually hear. Sorry?
California doesn't get to.
Hold on. Well, California is going to think it can. The painting was later sold at The painting was later sold at a Nazi government auction and passed through the hands of a variety of collectors, including ones in the United States, before being purchased by Baron Hans Heinrich Thyssen-Bornemisza in 1976. The Spanish government bought the Baron's art collection, including the painting, in 1993, and has been on display at the museum ever since. In 1958, Germany paid Kassirer the compensation of $13,000, or about $143,000 in today's dollars. Now, in 2000, she was the original owner, Lily's grandson, Claude Cassirer, discovered that the painting was held in the museum in Madrid, and he later filed a lawsuit in federal court in Los Angeles to try to recover ownership. After Claude and his wife both died, their son, David Cassirer, became the plaintiff. As a Holocaust survivor, my late father, Claude Cassirer, was very proud to become an American citizen in 1947, and he cherished the values of this country, David Cassirer said in an email. He was very disappointed that Spain refused to honor its international obligations to return the Pissarro masterpiece that the Nazis looted from his grandmother. Although he passed away during this long battle, he would be very relieved that our democratic institutions are demanding that the history of the Holocaust not be forgotten. Thaddeus J. Stauber, a lawyer for the Spanish Museum, said that the new California legislation should not change the lower court's decisions regarding the painting. Our position remains, and always will be, that a United States court sitting in California does not have jurisdiction to hear and resolve disputes over property that is in Spain. Stauber said, I don't think the people of New York would like to have, let's say, Russia or the UK or another country telling the citizens of New York, here's how you have to deal with property issues in your state. And I think, Andy, that's what you were saying, is how can you have, hey Mark, good to see you, how can you have a situation where you have one country or a state within a country, California passed a law that's going to tell Spain what or what not to do. So that is the current thing. But what's interesting is that the Supreme Court 9 days ago, March 10th, ruled that it should go back to the Court of Appeals in light of the new legislation passed in California, so they should re-examine the case. What that decision is going to be, the Supreme Court did not rule on this case, but it just said that the lower court, the appeals court, should re-examine in light of the new legislation. So what's interesting is that there is a claim that international law does provide for the restitution of looted art, of looted Holocaust art. This is not something that is the first time it's come up before the courts. There have been agreements by countries, by nations, to provide some measures of restitution, and really what in essence may turn out to be a U.S. versus Spain debate. What you have here is the U.S., or at least California, but it seems like the Supreme Court is acknowledging that legislation passed in California, kind of saying, here's the law saying that, there should be some sort of restitution here happening. And so it seems like the U.S. is, on some level, encouraging Spain to do the right thing and hand over the art. And so the question as we open today's class is, what do you think? Not what do you think about the legal dispute between the U.S. and Spain, or California and Spain, or, in the various courts, but what do you think should happen with the artwork? If you were the judge, oh, wait a second, you are the judge, because this court is you be the judge, which, if we fix the grammar there, you are the judge for right now. And so my question to you is very simple. It's 2025, right? It's March 19th, 2025. What say you about this piece of art hanging in a museum? Should it remain? Should it be returned to the family? Should it remain and some financial compensation be given? What do you say? If you had to craft the law, if you had a rule on this, not constricted to the various, limitations of U.S. law or Spanish law, but if you had to kind of create your own law, what would you say?
What does international law state?
I don't want to know about international. I want to know what Larry thinks. What do you think should happen with the art?
Go back to international. There has to be some precedent.
Okay.
So I would take what
Precedent, I'm sure, is mixed. What do you think? What do you guys think? Anybody?
It should go back to the original.
You say it should go back to the family, okay? All right, let's ask it this way. Probably easier if I give you multiple choices. So, raise of hand, who believes that the art should go back to the original owner? To the heirs. Okay? Mixed, okay? Who thinks the museum should keep it? Okay? All right. We got some hands going up for that. Is there a third option?
Well, no, my parents were Holocaust survivors and lost property during the war. And at the same time, my mother was in a position where she paid bribes. So the question is, if this woman had paid cash and not a painting, you go back to whoever she paid cash to.
And get the cash back.
I want money. Is it
Good.
the whole issue, the fact it's a painting, but there were so many bribes paid and
Right.
And so forth. to accomplish survival. So
That's an interesting argument. Good.
I completely agree with that, but for the fact that the dispute is not between the Holocaust survivor and the Germans, right? This is Spain, right? So assuming that the Spanish were innocent purchasers, that they didn't know where it came from or what was going on, which maybe you can assume that, maybe you can't. But assuming that to be true, then they've got a legitimate beef. I mean, they've got a legitimate claim.
They bought in good faith.
They're an innocent purchaser. They bought it in good faith, and I would say they are either entitled to retain the painting or to be compensated by somebody, probably the Germans.
Right. In other words, you're saying it's not Germany. It's not like you get it back from the Germans. It's now in Spain. It traveled through many hands on the way there. Good. Yeah.
But at some point you have to look at the big picture of what is the right thing to do. I mean, yes, the law says the property, it's in Spain, so Spanish law presides because that's where it is. And how can California tell Spain what to do when it's in Spain? But then the bigger picture is, what is the right thing to do? Where does it rightfully belong? Or at least the third option, option C, could be leave it where it is in Spain, but give restitution to the family. Give
Some
the value
measure
of
of
it.
restitution, whether full value or partial value. Okay.
With
Good.
an acknowledgement that it's on display in Spain so other people can enjoy looking
For the
at it.
public.
But it belongs to this family. It was.
So at least they're going to get some money. Okay, good.
Even though it was a bribe, she did get something in return. She got her life
She got a
in
visa,
return,
right?
She got a family from that life.
Okay, good.
She later
Check.
received compensation from Germany for the painting.
She did get some compensation. You're right. There was $13,000 of compensation. So it seems like, are we double dipping here? Perhaps.
Like if she didn't have to accept the compensation. Seems
Right.
like to me her argument would have been against Germany.
Right. Good.
Well, as an aside, I do think it would be really the right thing to do for Spain to put some kind of a plaque under the painting commemorating something.
Right.
But what I was going to ask you was about 4 classes ago, I think we had a similar case, but it had to do with maybe you take something, someone asked you to watch something or something with the goat or whatever, and there was this and that, and in this case, yes and that. So if we apply that, what's the answer?
Now I have to remember how we're going to apply goats to this situation. Right. Yeah. So what we're going to do today is really go through Talmudic sources on this and talking about lost property, stolen property, because the Talmud does give us a framework for approaching this, and hopefully today we're going to apply this to this case and other cases. This case is the reason why I wanted to show this case is because it's so current. And by the way, this is the art. I'm sure you all saw it, right? It's actually beautiful. It's really beautiful, Jay. Oh, good. Very good. Very good point. Jay is saying, what about statutes of limitations? Good.
If you have a lien on a piece of property and if you let it go 7 years without renewing it, then the lien just disappears.
Right.
So you have to make some action that it's yours.
Right.
You can't just sit on your haunches and say,
Right. They might say that once they discovered it in whatever it was when they discovered it in the museum, they had no idea where it was, then maybe that's when they filed a claim. But you're right, statute of limitations might technically run out. That would be something to take a look at.
It's called laches.
Nice.
The term is laches. You can't sit on your rights for years and years and years.
For too long.
Come back and say,
You got to get on it.
Yeah, what about the passing of time? It's been many years.
Right. Same idea, statute of limitations. Good. Yeah.
So there must be precedent because there's been thousands of works.
A lot of precedent.
that are found and returned to the clinic, for example. It's a very famous case, a woman in gold. And so there must be hundreds of precedent that is similar to this.
Yeah, I think what's unique about this case is the amount of time that has elapsed. The fact that Spain is saying that they had no idea. It's not like it changed so many hands. It came to America. They then bought it legally or lawfully, legally as far as they were concerned. And so even though there might have been some international precedent about returning some works of art, I think it's always been a bit of a complicated thing. And it's kind of, each case has been ruled on its own.
Another thing to consider when Germany compensated her.
Yeah.
Was that the real value of the painting at that particular
I had the same question, right? Is it essentially paying for it, in which case maybe at that point she waived her rights to ever get it back because you got compensated for it, it's over? Or was it like a token but not really considered compensation? Mark?
Well, along those same lines, the descendants are the ones that are bringing the lawsuit. Just about what Larry said, at the time she said, I'll give you the painting for you to give me safe passage so I can survive. At that point, was her intention ever to, if she were alive, to ever retrieve it or say, basically, I got what I wanted out of the deal.
Right. I got the value that I see for it.
Spain was a bona fide purchaser. The item does not become infected. The infection doesn't. What may have been a duress in the first instance doesn't so infect the item that the bona fide purchaser suffers from that, I think.
Okay.
I think the fraud is cut off.
At some point, it's not related to the Spanish museum that has it. And that's really their claim. That's the core of their claim is really not even about the passage of time, which is a factor. Their core claim is we bought it in good faith. We did nothing wrong. We paid the market value for it. The only counter to that I could see is the claim that a museum should have done its due diligence to follow the provenance. I think that's the right word. The kind of that we would say in Judaism, the yichus, right, the lineage of where this is coming from and sniff it out. I mean, can a museum do that? Should they be expected to do that? Did they know that and say, sue us? Try to pull it away of our hands? I don't know.
There's actually on a very local level, a much more simplistic thing that's been going on, where a person bought a car and bought it from a legitimate dealer. Story goes, they finally discovered the car was stolen, and the police took the car, repossessed it, and returned it to its original owner. And the issue was they had changed the serial number and so forth. And the argument was there are ways to find out. There's something that in the computer system, if you were to check, you would realize that it had been tampered with. It goes back to the original owner.
Right.
But is there an obligation to do that? There may not be an obligation.
An expectation.
Yeah. And that's another distinction. And Mike, that's an important distinction because maybe we might say that there's two levels to which by which to look at this, the legal dimension and maybe the ethical, moral, dimension of it, and they might not be the same.
It's really hard for a lawyer who goes to law school to separate law from morality.
Yeah. Yeah.
One has nothing to do with the other.
Right.
Especially because law typically takes 15, 20 years to catch up with you.
Right, interesting. Very interesting. Okay, so what we're going to do today. So all of this was the opening case, just to kind of get us thinking about some of these considerations. What we're going to do today is look at Jewish wisdom on this, based on the Talmud. And I think it's going to be a very enriching conversation and a conversation that really opens our eyes to some very important Jewish principles. And I just want to map out what we're going to be doing in this class. We're going to start with, it's actually very cool. We're going to start with biblical verses. It sounds like Jeopardy. We're going to start with biblical verses for 500, Alex. Biblical verses. We'll then get into Talmudic teachings. We'll then kind of like just following the arc of history and development of the oral law. So scripture, the written Torah, the Talmud, the code of Jewish law, and then modern poskim, modern decisors of Jewish law, and how they applied all of these principles to modern cases. So we begin with the verses. Now, text number 1, these verses speak to and speak about the obligation to return lost property. That is where we're going to start with this examination from a Jewish perspective. We're going to start with the obligation. Just to clarify, we're in the main booklet. So we're going to start with the obligation to return lost property as defined and described in the Torah, in the Jewish Bible. And here we'll see the contours of the obligation to make sure that an item is reunited with its rightful and original owner. text 1. Karen, please read text 1. Take it away.
If you see your brother's ox or sheep going astray, you must not ignore them. You must return them to your brother. If your brother is not near you, or if you do not know who the owner is, you must bring the animal home and keep it until your brother identifies it. Whereupon you must return it to him. You must do the same with a donkey, an article of clothing, or anything else that your brother loses and finds. You must not ignore it.
Thank you. So what we see from here are a few very important principles. Number 1, the obligation to make sure that items are reunited with their owners is incumbent upon all of us, and it is a proactive obligation. It's not like if it happens to land up in my yard, then I need to deal with it. No, if you see it, if you recognize that this could be a situation, it's going to lead to a situation where this person's property, item, whatever, is going to be lost, then you have an obligation to collect it and then seek to return it to its original owner. We call this, in Hebrew, we call this hashavas aveda, returning lost items. Now, if you notice, I'm sure you did, the examples that the Torah gives, these are biblical examples: ox, sheep, donkey, clothing, and then it says anything else. The obvious question is, help me out, what's the obvious question is?
What is anything else?
Well, first of all, you can say, what is anything else? But if you've already said anything else, then why do you have to bother specifying ox, sheep, donkey, and clothing? You with me on the question? You gave 4 specific items, and then you said, oh, and everything else. So then why'd you bother? Why not just say, if you find anything of your friends? So, of course, questions like these is like, it's field day for the Talmud. The Talmud loves these types of things. It's like, oh, you gave me 4 specific categories, and then you gave me the large catch-all category. What does it all mean? And so we're going to learn in a moment what it means. What the clothing, why the Torah specifies clothing if it could have just said everything. The Talmud does this for each and every item. Why does it say ox? Why does it say sheep? Why does it say donkey? Why does it say clothing? We're going to explain the clothing piece because it's going to be relevant to our conversation. You with me so far on the process? We haven't explained it, but this is the methodology. Yes?
I think the animals are also for kindness to animals.
Could be.
So
Could be.
They're cared for and survive.
You also could say, I think,
Loss of life.
could, right.
They're just wondering.
I can say, you could also say I like that. Another intuitive approach would be, well, animals can get lost on their own. I mean, typically a water bottle is not going to, make its own way out of the area, whereas animals can, and therefore it becomes the obligation to make sure that you collect it before it runs away. Okay, good. So text 1, just to be very clear, make sure we're all on the same page here. Text 1 is the Torah's. Is where the Torah outlines the obligation to return lost property. Okay. Now, is there a statute of limitations on this? The answer is no. To highlight this, the Talmud tells us a story of Rabbi Hanina ben Dosa. It's not here, but I'll tell you the story. There was a man, a rabbi. His name was Rabbi Hanina ben Dosa. And one day his wife sees outside their house, someone has left some chickens. Chickens arrived. There are chickens right outside her door. So she tells her husband, someone left chickens here. He says, all right, well, maybe someone put them down. Again, different eras, right? Someone put them down, is going to come back, take them inside, make sure they're protected so they don't get lost, because that's text 1. That's the obligation. So she takes them inside. Then they lay eggs. The guy never comes back. No one knocks on the door. They lay eggs. And what happens with eggs? It's not like the eggs that we know. It's the real eggs. What happens when you have chicken eggs? You also have baby chickens. And soon, the Talmud tells the story, very soon the house becomes overrun with chickens. And she tells her husband, what do we do now? He says, all right, sell the chickens and buy a few goats. She sells the chickens, so many chickens, there must have been a lot of chickens. She buys 2 goats, and they keep the goats outside. Years later, a guy comes knocking on the door. Say, yeah, can I help you? He's like, on the off chance that you remember this, I left 2 chickens here years ago. 5 years ago, let's say. You happen to have them? Kedina Mendoza answered. He said, here are your goats. They're yours. And with this, the Talmud highlights something that's really important that addresses one of the considerations that we brought up in the Holocaust art case. There is no statute of limitations in halacha on the obligation to reunite rightful owner with their items. There is no statute of limitations. Now I know that text 1 is talking about lost property, and our case study was about stolen, looted property. I get it. But the core concept that we should all be endeavoring to reunite item with owner does not in halacha have a statute of limitations. It could be years later. You gotta hold on to it and make sure that it gets reunited with the original owner. Now, are there exceptions to the rule? Like, what does this mean? In all cases, all times, you can never keep something that you find? Is there never a possibility to gain ownership over something? I mean, what about the people that walk the beach with those beep, 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 right? What are those things? Metal detectors. What about people that look for shipwrecks? What about, I don't know. Think of so many examples. People find stuff and keep it. Well, there's no provision in Judaism and Torah law for keeping something that you find. There's no kinds of finders keepers. You always have to hold it for the original owner, for the actual owner. So we have text 2. Text 2 is from the Talmud. Remember I told you before that the Talmud explains why the Torah gives the example of clothing? All right, well here's text 2. Larry, do you have a question?
Yeah, of course. So with the chickens.
Yeah.
Is there any obligation? What about the baby chicks that were produced by the 2 chickens?
Yeah.
Who do they belong to?
They belong to the owner.
Okay. And
Yeah.
as the one who was keeping them, fed them all these years, does he get any compensation?
Excellent question. In halacha, we would say that there's basic compensation for the care that was given. You don't have to do it for free. But the profit, i.e., etc., is attributed to the owner. So you can take basic maintenance fee, whatever that would be, but the profit goes. So if we paralleled it to the art, the increase in value is attributed to the original owner. Now, if you stored it, took care of it, maintained it, whatever, then you can charge a fee for those services, but you certainly cannot say any increase in value or increase in chickens, whatever the case is therefore mine because I was taking care of it. That's not how it works. It's owned by the owner. Now, what's the exception? Does ownership never come to an end? Text number 2 explains how ownership can actually be transferred. Larry, take it away.
In this passage, the Torah says that a finder must return every lost thing of your brothers. But it also singles out for special mention a lost ox, ass, lamb, and garment. Since the garment is obviously merely a particular example that is already included in the Torah's general command to return all lost property, why was it singled out and mentioned explicitly? Lost garments were singled out to illustrate a point to make us compare garments with other lost objects. The Torah is saying to us, only objects that are similar to garments must be returned. A garment is special in that there is identifying marks on it, and as a result, it has claimants. It is a man-made object in which its owner has made some investment, and thus he will not give up hope of recovering it. So too must everything that has identifying marks on it and has claimants be announced. The lost objects that are not marked or not likely to be claimed need not be returned because their owner will have given up hope of recovering them.
Thank you. So here the Talmud clarifies a huge principle. This is Tractate Bava Metzia, and this is one of the first Talmudic tractates that in yeshiva you learn when you first start learning Talmud, and it's the principle called Yiush. Yiush means despair. When you, in your mind, you give up hope, you despair of ever seeing it again, of ever hoping to recover it again. Now, why would a person despair of ever seeing it again? The Talmud has given us two examples. Number one, the obvious one of text 2, is where there are no identifying marks on it. So you know you lost something, but how are you going to identify it? If the person found it and you say, "Oh, that's my thing," they'll say, "Prove it." You'll say, "There's no way." So then you'll despair of ever seeing it again or ever being able to gain ownership over it, because what exactly are you going to say? How are you going to prove that it's yours? There are no identifying marks. There's nothing unique about it that makes it yours. So, for example, a coin. If you lose a coin in the street, you will presumably despair of ever seeing it again. Why will you despair of ever seeing it again? Because if someone picks it up, they're not going to know whose coin it is. And even if you come and say, "Hey, I lost the coin," they'll say, "Prove it," and you have no way of proving it. You can't say, "Oh, it's the coin that has my name on it." There's no name on the coin. Now, the mechanism by which the Talmud learns this out is by the fact that the Torah specifies garment. You and I today, garment would be the same category of a coin, because your Calvin Klein shirt or whatever you're wearing, right? That they make 1 million of those. But back in the day, when people made their own clothing, it was very identifiable. Like, I sewed it myself. I can tell you exactly where I messed up. There's absolutely what we call a siman, a sign, identifying mark on the item. So, in short, not to lose the plot over here, in short, the Talmud is expounding on the Torah. The Torah says, if you find something that's lost of your neighbors, you have to return it. Collect it, keep it safe, and return it. Endeavor to the best. And it's not yours. And it never becomes yours unless that owner despaired of ever seeing it again. It's a mental process that creates a transfer of ownership. It's actually wild how a cognitive element actually has the ability to change legal status of an item. The very fact that the person despaired mentally of ever seeing it again means that for that person, they have sundered, they have cut, severed their attachment to that item, and now it becomes available to whom? To the one that now has possession over it. We derive this from the fact that the Torah cites the example of a garment. Why say garment? Say everything. We just said everything. Why say garment? Garment tells us, just like a garment has a sign, only things that have a sign have an identifying mark. Things that you can't identify, that you wouldn't be able to specify and identify, you will have given up despair, and therefore, if you've despaired, then it's no longer yours. It belongs to the person that has found it. There's a very, very important principle over here. First of all, this principle is very important. What it means is, even if you know who lost it, you with me on this? You might know who lost it. But if you can presume that they've despaired from ever seeing it again, you can legally keep it. Now, I'm not saying you should. I'm not saying there's not an extra legal obligation, which we'll get into in a moment. But legally, the moment they've cut their mental connection with that item, it becomes available. And if you pick it up, it becomes yours, even if you know actually who it belongs to. Make sense?
So if you see somebody drop money on the street.
That's it. That's the example. Imagine you see somebody all the way up ahead. There's one person in the street, and you see them pull something out, and you see something drop to the ground. You can't. They're so far away. It's clear day, and it's flat. You can't even call out to them, and they're gone. They get into a car and they speed off, and you see it's a $100 bill. You see it there. It's a $100 bill lying on the street. You know who dropped it, but you also know that them upon they're in a cab, they're in a car. Upon checking their wallet and seeing that it's not there, they're like, great. That's gone. If you can, now the question is, well, how do you know what they're going to think? So there's two ways. There's either the collective assumption that we will apply, that the court will apply. Like if we don't, in absence of specific knowledge about the awareness of the person or the mental state of the person, we will presume that most people, under most circumstances, having dropped a $100 bill that they haven't memorized the serial number on, and probably might not even remember where it fell out, and even if they do know where it fell out, we'll assume that whoever picked it up probably is going to pocket it, because how will you prove that it's actually yours? So with all those factors, probably that person will have given up hope, even though you know who it belongs to. Let's say you know that's your friend. Legally, it's yours. Now, there's a question if you picked it up before they know about it, so meaning they haven't yet despaired and you've already picked it up. Can you take ownership before they've despaired, or is it only after? That's a complicated dispute in the Talmud between Abaye and Rava. We actually rule that like Abaye, that you don't gain ownership, but if you sold it to someone else, or if you transferred to someone else, they could gain ownership because it was after, we presume it was after the moment of despair of the person who lost it. Yeah.
I was just going to mention that in the Talmud class I take, I asked the question, when we studied this, I asked the question, I play golf.
Yeah.
And people mark their golf balls.
Yes.
And when you find a golf ball, I said, I play with a lot of used golf balls. A lot of them have marks on them.
Yep.
I said, what's the story on that? It's a problem. It's
Well-
a problem. It's just a golf ball. That's one thing. It's got a mark on it.
No, so listen, what's crazy about this is that I was thinking about a similar situation with golf balls. So I recently listened to a podcast that talks about a business, people have these businesses where what is their business? They go into the lakes in golf courses and they collect the balls and they clean them up and then they resell them. Usegolfballs.com, whatever the website is. And you can buy like good golf balls and it's like 50% off. So people buy it. It's great. It's a win-win. Guys, they literally put on diving suits and go and collect balls. They do that all day. They sell them and that's it. And you know what? I hear the interview with the guy. He said sometimes they have markings. He said he's had celebrities. He's had a golf ball that, because Trump has his own initials or whatever on it. So the point is that he has sometimes these celebrity balls. He sells them for more. And so I was thinking the legal question. So you know whose ball it is. It's not a question. It's smart. That's your question, right? But it was hit into a lake. The moment so that's what I was thinking. I think it's a classic case of text 2. In other words, this is the perfect case. It's your golf ball. It's,
Yeah, but like I can say from personal experience, once you lose it, you say it's gone.
It's gone. You despair. And halacha wouldn't have to ask you. The judge wouldn't have to say, Mark, what was your mental thought when you hit into the lake? We assume that most people hitting into the lake are not planning on getting into a wetsuit and diving in to get it, which means that you have assumed that in your own mind, the second it goes in,
It's gone.
sayonara, baby. See you never. Right? That's your mindset, which means that in halacha, at least, again, how this works in U.S. law, I don't know. I think it would be an interesting question. Clearly, it's not, because someone's making a lot of money on this. But in halacha, there's no question, literally based on the Talmud. Will be read in text 2. You only have an obligation to return lost property so long as the owner has not despaired. The moment they've despaired is the moment they have cut their ownership, their relationship with that golf ball. In this case, the golf ball, which means it's now available. Finders keepers. There's another case. This case is even more dramatic. Yeah.
Isn't there some kind of salvage exception in halacha?
Salvage meaning?
Meaning, even if you know whose it is, if they've lost it and you've gone to considerable effort to achieve to obtain it, like getting into the wetsuit and going into the lake, it doesn't matter what their state of mind is. It's yours by right.
According to the commentaries, the reason why it's yours in case of salvage is because of their presumed state of mind. Now, if they could somehow definitively prove that they went to their car and were about to get into the suit because of this, could you say that they are marked as an exception and the typical protocol doesn't apply? I don't know if you can say that. I think once we make the rule, we make the rule. But maybe you could say it's depending on a case by case. But it's typically, you're right about the salvage, but it's because of the mental state. In other words, the 2 points are connected. They're not independent. It's connected. The reason why when you go to extreme lengths to recover something, why it's yours, is because the previous owner, who did not go to such lengths, we can assume despaired of ever seeing it again. You, the one who went to extreme. Now, where do we see this? We see this in text number 3. Mindy, please read text 3. This is again from the Talmud, and this gives us the second exception. Remember, exception number 1. So the rule is, if you find something, you got to return it. Exception number one, there's no identifying mark. How's the person's going to despair ever seeing it again? It's a coin, it's $1, it's a Calvin Klein shirt. How are you going to, without your name in it? That's exception number. Exception number two is found in text number 3. Please take it away.
From where in the Torah do we know that a lost object of any kind, even one containing an identifying mark, that was swept away by a river, is always permitted to be kept by the finder and need not be returned to its original owner? As it says, so shall you do with every lost thing of your brother's, which is lost from him, and which you have found. From the presence of the seemingly superfluous word from him, the rabbis drew the following conclusion. Only that which is lost from him, for example, as far as its owner alone is concerned, but is available to everyone else, must be returned. By inference, this excludes an item which was swept away by the river, which is not only lost to its owner, but is not available to anyone else either, since the river is likely to carry it away altogether. Accordingly, the Torah declares such an object to be ownerless, and it need not be returned, even if the original ownership is not in dispute.
So, thank you for reading that. So, what is this teaching? This teaching is like the golf ball in the river, the golf ball in the lake. But the example here is more of like a tsunami or a flood. Now, in modern times, maybe there's other ways in which we wouldn't despair, but in ancient times, and you had a massive flood, or let's say, God forbid, a tsunami or any of these things, and property was swept away, the owners despaired of ever seeing it again. It's probably destroyed. It's probably water. It's probably beyond, salvage. And at that point, the owner's like, all right, it's done. It's done. Which means that even if by chance you somehow get into the river or salvage it, whatever it is, and it has someone's name on it, you know who it belongs to. Doesn't make a difference. You can keep it. Why? Because again, this idea of yiyush, this idea of relinquishing hope, relinquishing expectation of ever seeing it again, the moment your mind determines, that's it. That's over. I'll never see that again. The moment your mind says that to itself, it's not yours anymore, and whoever finds it can keep it. 1 second. Hold on. That's exactly what's at stake over here with the Holocaust art. What was the mental state of the people that it was looted from? We're going to get to that in a second. Text 4a. Andy, text 4a. Now, what we just read, text 1 was the verses in Torah. Text 2 and 3 were from the Talmud. Text 4a and 4b and text 4a and 4b are now from the Code of Jewish Law, Shulchan Aruch. 4a, please.
If someone salvages property from a lion, a bear, the rising sea, or an overflowing river, it belongs to him. That
is the way the halachic code stated. If you go to extraordinary lengths to recover property, it's yours. I have someone's name on it. They had no expectation of seeing that again. It is completely yours. If you're the Meshuggah, if you're the crazy person going into the lion's den to retrieve something the lion took, you can keep that thing. Not recommended to do it, but you can keep it. 4b, please. One more.
A group of people was traveling through a desert, and a large group of bandits robbed them of their belongings. Then, if one of the travelers risked his life and managed to save an object from the hands of the looters, he may keep it, as the owner surely despaired of recovery.
This is a crazy scenario. Thank you. This is a crazy scenario. Imagine you're with, none of us, right? Imagine someone is with a group of friends, and these bandits come, and they rob everyone. And by the way, in the Talmud, I don't know why it wasn't translated, if under normal circumstances, like there's no way to get that back, because these guys are armed, they have machine guns, and they took everyone's wallet and cell phones and whatever, and valuables and jewelry, and some crazy person from the group takes them on, Rambo style, and gets back someone's wallet. You know what the ruling is in Jewish law? You can keep that. You may lose a friend. You will lose a friend. But halachically, the moment it was robbed, right, is the moment that person said, I'm never going to see that again. If you go ahead, in a crazy act and take it and get it back, that doesn't belong to that person anymore. They yiyush that. They gave up. They despaired.
How do you measure? Was surely despaired of recovering it. If it's Granny's watch and it's a Boulevard watch that came out of Woolworths, it's got no value, but it's got very little value. But it was Granny's watch.
Right. I think what it means is that in the situation of armed robbery, if the owner can be presumed, if we can assume that the owner thought, this was just robbed, I'll never see this again. The moment that thought crosses their mind, they have lost legal title to it, as it were, in halacha. And therefore, now, if someone goes in and takes on the robbers and gets it back, it now can belong to them, even though we know whose watch it is, and even though it might be valuable, whether sentimental or real. The moment they despaired of ever seeing it again is the moment that now it becomes available.
So I picked up a book that Rabbi Feldman had written, and then I saw that he had signed it, and then I took it back to the office to find out who it was, because it was important to them.
Right.
Are you telling me that person said, I haven't seen it in a year or two, so I'm through with it, and I'll never sign it again?
It's a good question. I think it's more of in the moment, right? So your question is on an actual situation. How would a person determine whether or not someone else would have despaired? You find something. How do you know what's in their state of mind? How do you know if they're still looking for it? How do you know what they're? You're right. It's more of the court saying, okay, here are the parameters of the case. Here's the situation. We're going to say, you know what? At this point, if let's say you find something that's old. Even though statute of limitations doesn't typically apply, but let's say you find something that's been buried underground for 100 years, you're going to assume that the owners have despaired of it, and at that point, it's available to take. The real thing is like this. The rule is, again, we have to make sure we know what rules and what the exceptions are. The rule is, you got to return the property to who it belongs to. The exception is, if they have relinquished hope of ever seeing it again. And there's two scenarios where that might happen. Number one, where there's no identifying mark in it, or number two, where it's such a violent or such a dramatic situation of loss, where under normal circumstances, the person is never going to see that again, whether it's armed robbery, whether it's flood, tsunami, act of who knows, whatever it is, lions and tigers and bears, oh my. If under normal circumstances you're never going to see that again, then we can assume that the owner's despaired and you can keep it. Yeah.
Does the finder of an object have an obligation to publicize?
Typically, yes. Under normal circumstances, the way to find the owner is by announcing that you found something, and therefore you kind of trigger that. But in a case where you can presume, by the exception cases, you don't have to, you just keep it, which is, again, kind of crazy.
What about items that you purchase, and at the time of purchase you're told, if this is lost, it will. If you ever lose this, it will be able to find its way back to you. Like I'm thinking of an iPhone.
Fantastic question.
I'm thinking of an iPhone.
You heard Mark's question?
Somebody drops it. It's in a river.
Great.
He drops it.
Let's forget the river.
Forget
the river. Talk about robbery. Talk about theft. Okay. Right? So Mark's question is, if you have a Find My iPhone thing on it, right, and it's stolen, one could argue that you're not going to despair. Why? Because number one, you have identifying marks. Number two, you have a way. There's an app to get that back. Again, halacha doesn't say in all cases of robbery you can see you later, alligator. It doesn't say that. It depends on the mental state of the owner. Did they despair? Did they not despair? In a case where there's an app, I would presume that people won't despair in that situation. Yeah.
You used the word despair, but there are items that are clearly, there's no reasonable expectation of return.
Yeah.
I'm not, I can make better sense out of that test than despair. Is that?
Yeah.
Are they the same?
It's the same. The reason why I'm using the word despair is that it's a more literal translation of the Hebrew word yush, but don't worry about that. Whatever the concept is, you have the concept correct. The concept is where I've lost the reasonable expectation to ever see it again. The moment I'm like, the moment you tell yourself I'll never see that again is the moment halacha says, guess what? It's gone. It's no longer yours.
If you lose them, they're gone.
Say it again. If what?
From the moment of purchase of an item, of some items.
Some items.
You know, if you lose it, it's gone.
You're never going to see it again. Correct. Correct?
So, dogs are often shipped. Valuable dog.
Yes.
Dog gets out of the house.
Yes.
Publicized everywhere, you don't see the dog. 3 years later, you're contacted by someone who said, I brought my dog to the vet, I bought this dog knowing I bought this dog when it was clear, I brought it to the vet, Chip brought it back to you, identified you as the owner, do you get the dog?
Yes. It's not a question. Why? Because halacha says, remember the rule and the exception. The rule is you have to return lost item. Now, what if you didn't know it was lost? Doesn't actually make a difference. Halacha doesn't care necessarily about good faith. We said that relative to international law. Spain cares that they bought it in good faith. Halacha doesn't care whether or not you found it in good faith or whether you bought it in good faith. The reality is it still belongs to the owner. What has severed ownership? What mechanism is? The only thing that can sever ownership is intent. No, it's really intent.
It's like a violent dog robbery. You're so violent you don't think you're ever going to see the dog.
Well, then that might change the situation. No, but if you have a chip, then you'll think you will get it again. It's not. There's no. In other words, it's all very logical. It's actually always about the mental state. So, for example, if you gift something, what transfers it? The fact that you decided that it no longer belongs to you, it belongs to them. If you sell something, what transfers ownership? The same thing. The fact that you decided it's no longer mine, it's yours. If you lose something, or if it's stolen, what can transfer ownership? Only your mental state. No one can pull it away from you unilaterally. You have to give it up before they can take it. If you've never given up hope, even in a violent robbery, God forbid, if the dog is chipped and in the back of your mind, it's like, this is insane what's happening, but you know what? At least we have a chip. Someday it may come back. That's enough to keep it yours. Now we say to the person who bought it, sorry, go back to the person you gave money to, trace that back, figure that out, but this is my dog. Halacha would be very clear on this. In fact, let's take it a step further. Even in cases where we say the person probably gave up hope and probably abandoned hope of ever seeing it again, even in those cases, if you know who it belongs to. Text 4C says, Andy, one more. 4C on the next page. Yeah.
However, it is good and just to return.
So here we're introduced, the Ramah, Rabbi Moshe Isserles, here we're introduced to an extra legal, ethical obligation in the code of Jewish law that's prefaced by, this is not the law, but you should still do this. Now, the commentaries, poskim, have a dispute whether or not the courts can enforce text 4C. You with me? Can you enforce this good behavior, or is it literally left up to the individual to decide whether or not they're gonna behave nicely? But text 4C says like this: even in a situation where the person has abandoned all hope of seeing it again, in their mind it's a goner, and then you find it because you're the hero that goes into the lion's den, or because you're the Meshuggah that goes into the tsunami, or because you're the guy in the wetsuit that goes into the lake to collect the golf balls. If you know who it belongs to, you should, not have to, you should return it. Can the courts enforce a should? Some say yes, some say no, most say no. Now, this leads to cases. Case after case after case that came up after the Holocaust, shortly after the Holocaust. We started today's class with a case that's happening right now, but you know what? That art was taken in the 40s? So many decades, 8 decades old, that case. What about cases that were adjudicated that came before rabbinic courts and other courts in the 50s and 60s, or 40s, 50s, and 60s? We have these cases, and we can study these cases, and we're going to study them right now. Before we study the cases, the Holocaust cases, we have a series of cases that will then inform our opening case, the modern case. Before we do that, we have to, one more caveat, an exception to the exception. Text 5. Jay? Text 5.
Hebrew books.
Yeah.
Hebrew books which were stolen are always regarded as being in the state before the onset of disappearance. For it is not common for an owner of Hebrew books to despair of recovering the stolen books. The looter will eventually sell those books to a Jew who will then return them to its owner.
Thank you. Look at that logic. You with me on that logic? If someone steals Jewish books, even armed robbery, God forbid, a violent situation. 1 second, hold on. What are they going to do with it? Where are those Hebrew books going to end up eventually? Back in the Jewish community. And guess what's going to happen then? With your name inside it, assuming your name's inside it, they're going to find their way back to you, which means that you'll never despair. Remember, there's no hard and fast rule. It depends on not only the context of how it was lost or stolen, but also what was lost or stolen. When it comes to Jewish books, Hebrew books, the presumption is it's going to find its way back to the Jewish community. What else are they going to do with it? What else are they going to do with it? I'm thinking about my son's tefillin that were stolen, but that never came back. But nonetheless, it happened a few years ago from our car, from the trunk of our car. Whatever, it's still a traumatic experience. But the point is that halacha, this is the same Ramah. This is an exception to the exception, which brings it back to the rule. You see what the rule is? You got to return lost or stolen. You got to return an object back to its owner. The exception is if there's despair. The exception to the exception is Hebrew books. Why would you ever despair? By the way, this creates a difference, a fork between Holocaust looting of Hebrew books, Jewish books, and Holocaust looting of art. You with me? You with me on this? So the case studies that we're going to do are case studies that the first few case studies here in this booklet are about cases of looted books, Jewish books. Again, I want to just emphasize the logic. The logic is, if a book, a Jewish book, Hebrew book, whatever, is stolen, looted, whatever, where is it going to go? There's no other market. Who's buying that? It's going to go back in the Jewish community. So it's going to be in friendly hands. It's going to be in friendly territory. Done. I'll get it back. You never really despair. If we can presume that, then it remains yours forever. Yeah.
What about the Rebbe's library?
We're going to talk about libraries in a second. Text number 6. Jake, please read text 6. This is a real case. Rabbi Yaakov Reich was a survivor, a Holocaust survivor, born in Galicia. He then, after the war, he went to Zurich, Switzerland, and became the chief rabbi of Switzerland. Take a look at text, and he wrote extensively on issues of halacha vis-a-vis the Holocaust. Text 6, please. Yeah.
I was asked the following question. During World War II, the Slovak Nazi puppet government looted the property of the Jewish population. The current government of Slovakia now has thousands of Hebrew books and sacred manuscripts, which they are ready to sell. Is it permitted for a Jew to buy those books and keep them as his own?
Look at that question. The government of Slovakia has all thousands of Hebrew books and manuscripts, and they're looking for some cash. And now they're going to sell. Well, who's going to buy it? A Jew, presumably. Can a Jew buy it? It has someone else's name inside the book. Can you buy it and keep it? The incentive to buy it, of course, would be to have it. If you buy it, can you keep it? It's such a basic question, huh?
The assumption is the person that lost it never despaired because it was a Jewish book on the same logic you just said.
So if you apply text 5, which comes from Tosfot, quoted by the Ramah on Shulchan Aruch, Code of Jewish Law. So if you take the logic of text 5, this is a Hebrew book, you would say that the owners, therefore, never despaired. You can keep it. But there's a twist. Holocaust.
Can they try to find the right
1 second, huh? Does the Holocaust trump Hebrew book? You with me on the question?
What if the book is unidentifiable? It's just Jewish.
Well, then it has no simon. Then it's the first issue. Remember that it's all about presumption of mindset. What was the mindset? Was it there despair or not despair? In a typical situation, you're going to assume it's going to come back to the Jewish community. The question is, during the Holocaust, someone whose Hebrew books were looted by the Nazis or by a Nazi puppet government, what was their state of mind in 1940, 41, 42, 43? What was their state of mind? You understand my question? It might be different. It might not be a normal case of, the books will come back to the community. It might be the world is burning, our community is decimated. Who's gonna allow for justice to ever be performed? Text 7. Eve, please read text 7. This is Rabbi Yaakov Breisch's ruling on the case.
However, it seems that in our case, the buyer would not have a legal obligation to return the books to their owners. The reason which Tosafot gives for the exception applying to stolen books is that the owners expect the readers to sell the books to Jews, as no one else would be interested in those books. However, in the case of the Holocaust, we know how the original owners of these books were exiled from their homes, with nothing on their bodies, and there was no justice available for these poor victims. Furthermore, we know what was done to Jewish books in other lands of bloodshed during the Nazi control of Europe, where they burned the Jewish books publicly.
What he's saying here is, under normal circumstances, you would not despair of getting reunited with your Jewish book. But what about during the Holocaust? That's not a normal situation of losing a Hebrew book or having a Hebrew book stolen or even armed robbery. This is an extreme case of a Holocaust where you have, the Jews unfortunately, had nothing on their backs. They had no sense of justice. They had no expectation, perhaps, that anything would ever become normal again. Books were being burned publicly, and maybe in that situation, the owners would have despaired from ever seeing those books again, even though they're Hebrew books. And therefore, Rabbi Breisch rules that you could buy, listen to this, you can buy the books from the Slovakian government, and you can keep them. Because he says, we presume that the owners of the books in the Holocaust would have, even though they're Hebrew books, would have despaired from ever seeing them again. It's the Holocaust. That's what he says.
Even if it has the name in it.
Yeah. Because it's extreme circumstances. It's extreme.
How is that different than the case with the art?
Hold on, we're going to get back. We're going to get back there in a second. Yeah.
But it's like 4C, it is good to adjust.
Oh, yes.
You can buy it.
Oh, thank you very much.
Name identified
It's still good and just to return it if you know that. Yes, Mindy's correct. The legal ruling that Rabbi Breisch says is there's no legal demand, there's no legal obligation to return it because we presume during the Holocaust, even though it's a Hebrew book, everyone would have despaired. It's over. We're not gonna live. The community's gone. There's no justice. The world has turned against us. There's no way we'll see this again. Books are being burned, even though they're books. There's no expectation to be. However, if you buy a book and it has a name in it, the right thing to do to return it.
more so, you should buy it to get it back to someone.
Right, but you can't mandate that to people to spend money to return it. Text 8. Mark, please read text 8. This is Rabbi Isaac, I don't know how to pronounce that, Leibis, who also writes on a similar case.
Despair of recovering stolen property does not normally occur with regard to stolen sacred books, because the only way the thief may profit from such stolen items is by selling them to a Jew. Hence, the victim has no reason to despair of the return of such property. But this consideration did not apply during World War II, because the Nazis were intent upon annihilating the entire Jewish people, and it therefore did not enter the mind of any person that the books would again come into the hands of Jews, since from the day of the creation of the universe, there never was a terrible edict such as this, to annihilate, to slay, and to destroy all Israel. In such a state, if they already despaired of their lives, did they not most certainly despair of their property? To whom would it occur to think thoughts of his house or fortune, while under the nails of the angel of death, the impure, foul oppressor, in the death camps and in the ghettos?
That's the argument to say that yes, usually by books we say that you don't relinquish hope of seeing, but in the Holocaust, all hope was relinquished, all expectation of ever living normally again, of ever having property again, of ever reuniting with the property again. Certainly that was out the window. They didn't think they were going to even survive, let alone be reunited with their property. Therefore, there was a collective state of despair, which again, it may not be the best word, but a collective state of mentally relinquishing ownership over it, and therefore it would belong to the a person who purchases it or finds it, etc., because it is not theirs anymore.
I've got an interesting side note for that. A very close friend of mine who passed away some years ago, about 7 years ago. You met Paul Halpern. Paul bought a Torah, which was a very, very old Torah, which was saved during the Holocaust.
Wow.
Because they wanted to save it.
Yeah.
They knew the Nazis would destroy it. So it was taken apart, and it seems
Wow.
a special sofer did this. He dyed it brown, the same color brown, which you see with boxes. He wrapped the boxes, so the whole Torah is there. It's used to wrap to look like it's part of the box.
Wow.
And it was stored in the basement. The Nazis saw it, boxes.
They didn't touch it.
They didn't die, the boxes.
It's incredible.
They didn't know.
It's an incredible
And so
story.
He bought that. There was a sofer, one, I think one in the world was Israel, it was a very old script who could bring parts of the letters had to be able to remove the dye, it's a special dye they used. And
restore it.
They did it. It's a fantastic story. And in fact, the Torah is sitting
So I would say, yeah, where is it now?
Is that the one that's at AA?
Let's show.
Oh, because AA has a recovered.
That's an incredible story. What regarding our discussion today, what would
because they thought someday,
and that's where you see, even under normal circumstances, these two rabbis, Rabbi Bryce, Rabbi Leibus, they both argue during the Holocaust, everyone despaired of everything, but if somebody didn't, they didn't. Now we have a dissenting opinion. There was another case that came before the Bet Din shortly after the Holocaust. Here's what happened: somebody donated a Torah and a silver crown they had it be held at a synagogue, at a shul. But they said that even while it's there, it's still ours. It's still, it still belongs to us, but it's being held. And then the Nazis looted the synagogue, and then one day, a few years later, after the Holocaust, the son of the original owner, he sees the crown in a museum in Jerusalem. He says, "This is our family crown." Same question. Did they despair? Did they not despair? It all goes back to that presumption. There was another case. This is actually the case of text 9. There was a rabbinic seminary in Berlin called the Hildesheim Rabbinic Seminary. World famous rabbinic seminary. And the Nazis looted. They took the entire library. But there was one guy who worked in the library who, while this was all happening, he collected a bunch of books on his own and smuggled them out to safety. And after the war, he asked a question of the rabbi who had previously been a rabbi, I think the head of that rabbinical seminary. He said, "Can I keep the books? Because didn't you all despair of all the books? I saved them, I get to keep them, right?" Text 9. I'm going to read this now. "The Germans often used to take entire Jewish libraries and preserve them as they did with our library that is now in its entirety in Prague. Hope never fled from our heart during the Holocaust that this evil power would vanish like smoke. Comes along Rabbi Yechiel Yaakov Weinberg and he says, no, we didn't despair. Despair? We didn't despair. We always knew we would be reunited with the books." You see what's going on here? Different rabbis, different presumptions of despair. Now, you could say it might be individual loss versus a whole library. Maybe if they took a whole library, the presumption is that the library was going to be preserved somewhere else, which it was indeed, as opposed to an individual book, which is probably gone, which might be, despaired as being gone forever. So these are the point is that there is a dispute amongst various authorities about, even vis-a-vis the Holocaust, what was the state of mind? Or maybe you could say what the mindset in Slovakia was different than the mindset in Berlin. Perhaps they had different mindsets in different places. Now, there are a few more pieces to this, but I want to wrap this up, and I want to get back to our original case, because I think we have enough information to get back to it. There is one more question, which is the question of, well, do you say that looting by bandits and thieves and robbers is different than when a government seizes control over property? Maybe when a government seizes control, it doesn't matter what your mindset is. It belongs to that. The government's allowed to seize control. We say eminent domain, or din da machutz din, the law of the land is the law. If the government takes it, it's theirs, which means that whatever happens afterwards, it doesn't matter. So you might say that regarding the Holocaust, even if there was no despair, but once a government takes it, it's theirs. So if you buy it from the government, it's yours. So to this we have The Bet Din of Jerusalem said the following text, number 11. In our case, the principle of conquest does not apply, as the Nazis attacked the Jews who were living securely on their land under their sovereignty. The goods that they stole from the Jews could not be considered spoils of war. It should be categorized as plain robbery. In other words, when do you say that a country has the ability to seize control of items? That's typically when it's fighting a war with another country or whatever. But to in violation of law, to go and persecute its own law-abiding citizens and to loot them of their stuff is certainly not something that we could say is a valid form of conquest. So all of this, that's an attempted approach, and then we rejected. So let's leave that aside for a second, the idea of conquest. So let's kind of sort out what we've learned so far, and then let's get back, and then we'll conclude with our opening case study. So what we learned today is that in general, the rule is you got to return items back to their owner, with a few exceptions, which all come back to one principle. If the owner despaired of ever seeing it again, then it's fair game. And so the question is, what is the status of Holocaust art? It's not a book, right? We said by books there might be exception, but there might be an exception to the exception if it's the Holocaust. But by art, is there an exception? Here, this woman gave the art or traded the art for her life. Did she ever expect to see that again? Did she ever have an expectation to be reunited with that item? And if not, then we say at that point that she had yush. She had lost that expectation. She had mentally severed her connection with the art. She might have the receipt. She might have the provenance, as they say. I think that's the word, right? It might have been clearly in her family. She purchased it. The moment she relinquished hope is the moment, one could argue, there's fair game. Especially considering that it transferred multiple hands, multiple parties, and was purchased in good faith by the Spanish government to put in its museum. I know this is not the answer that makes us feel good Jewishly, but if you follow the halacha, in a case of yiyush, in a case of when hope is lost, the law goes as it goes. But, as Mindy pointed out already before, when there's no legal obligation to return it, there still may be a moral or an ethical obligation to return it. And I think, if I had to, because I didn't look at the actual rulings and opinions in the various court cases, in the Supreme Court case that just came down 8 days ago. But if I had to guess, that's kind of where the law is right now. Does Spain have the legal obligation to return it? I don't think anyone's going to say that. But is it the right thing to do? And I think that aligns with halacha. Halacha says, based on different factors, it's not about time, it's not about even good faith purchase. It's more about the fact that she probably never expected to see it again. And at that moment, it's like hitting a golf ball into the lake. Finders keepers. Purchasers keepers. But what's the right thing to do? You know who it belonged to. But here's where halacha comes in. We don't have text for this. You have to take my word for it. Some poskim rule the following, that in a case like this, there still should be some financial compensation. Right? Either some of the profit, some of the value should be given to the family, or alternatively, go the other way around. The art should be given to the family, and some of the money should be kicked back to the museum. But something to try to make both parties feel better about the situation. But again, to clarify, legally, my understanding, I cannot say that this is definitive. This is based on all of these rulings, all these teachings, and this case that's right now before the court. My belief is, based on this, that there was yush. I think she despaired of ever seeing that again. I don't think she held out hope of ever being reunited with her art. I think she believed that it was gone forever. The Nazis took it. What was her expectation at that moment? That she's going to somehow Rambo it back? That the war was going to end and she would somehow have a legal recourse? What was the hope? The thought was, it's gone. I would assume that her thought was, it's gone. Number one. That means that legally it belongs to whoever it belongs to now. Morally, they should try to make it right. What does that look like? Some sort of compromise. And that's where I think halakha would stand on this. Does it satisfy us? Does it give us the justice that we might want? Not necessarily. But I don't know that halakha could mandate that the museum return it to her if she gave up hope. Yeah, Mark.
So
Mark in the way.
one of the things we didn't discuss, but is there anything, and I'm sure this question has a lot of more discussion than a quick answer, but is there anything that defines what the descendant's right is to property?
Yeah. The short answer is, if it belonged to the original, then it goes straight down to the heirs. So that wouldn't be. It's a good question. It would just be the equivalent, and then straight down. They don't lose it because they're heirs.
In the case of that woman,
Yeah.
she did not sell her artwork.
She traded it.
She paid a ransom
Right.
for her life.
Good.
As such, when people pay ransoms, they often hope they will get it back. So I'm saying, following that line of thought.
Listen, if you and I could disagree on that piece of it, and I would say if you think that, then the law would change.
Yeah.
I can tell you what I think. I cannot imagine in 1940, whatever, whenever she traded that for her life, I can't imagine. Now, but I think I quoted rabbis that had a disagreement. The rabbi in Berlin said, we never gave up hope. Another rabbi said, we didn't think we were going to make it. We didn't think we were going to be alive, let alone ever get books back. We weren't going to make it. Forget the books. So if you tell me that there might have been different perceptions at the time, or we can have perceptions of whatever, and you and I might disagree 100%. I could see how you're looking at it. For me, I just don't believe that she would have thought that she's going to get. My presumption is she abandoned hope. That's my presumption. I'm not saying I'm right, but if you go with my presumption, then that's how the law would follow. If you go by your presumption, it might be different.
What occurs to me is that I understand that as the Jews were marching to the gas chambers,
Ani Mamin.
saying Ani Mamin,
Correct.
they did not give up hope.
But again, there's one question about survival, another one about ever getting the art back. Did she think in that moment, that long term, we're going to survive and we're going to have the wherewithal and the recourse to be able to get back, to pull it back out from the Nazis? I don't know. I personally can't imagine that. I can't personally. Maybe I'm wrong. I'm not saying I'm right. I'm saying if you follow my logic, this is how it would go. If you follow that logic, it would go out. If you follow your logic, she never gave up hope, which means she remains the owner of it, which means even though the museum bought it in good faith, it's still hers, and you would still have to do a compromise. You still wouldn't say to the museum they should lose all the value. They should at least be compensated with their purchase price, whatever they purchased it in 1993, 1994. There should be some sort of deal the other way to compensate them, but legally, it would belong to her, if you say that.
So what do her heirs have about her hope? I mean, they don't know what her hope was.
At some point, there's no one to ask. You have to just legally presume. Halakha would have to make a presumption. Who makes that? Your question is, who makes that call? I don't know. If I made the call, I told you if I made the call, what call I would make. You put a panel of 3 rabbanim, 3 poskim, who know what's going on, who maybe speak then, have interviews with people that were around them that had similar stories, and they ask them a question. What were you thinking? What was your expectation? What was your mindset? Maybe that's how you do it. Maybe you just literally speak to whoever you can to try to get in the heads of what was going on, and you might get different answers. And by the way, answers might change over time because, perspectives change. Hindsight is 20/20. Maybe now that we survive, now that we have the recourse, I never gave up hope. I don't know if I'm trying not to be, I don't think I'm cynical, but I just can't imagine that,
The theft, the sale, the ransom of the painting is the reason she has descendants.
Exactly.
When you think about it, that
Right.
painting caused her generations
survival.
What's more valuable, the life
Correct.
of her.
Correct. I get it, by the way. I totally get it. It's ours. It's our families. Our great-grandmother bought it.
It's worth millions.
It's worth tens of millions. So many. But I think if it came before a bet din, if it came before a Jewish court, there would be every effort made to make both sides feel better about the situation as opposed to making one the winner and one the loser in this type of situation. There's always the attempt to try to, not necessarily a compromise down the middle, it's not 50-50, but to at least throw a bone one way or the other, depending on how you land. But it all comes...
To make both sides equally unhappy.
Correct. Which, by the way, is a thing. By the way, is a thing. No, I'll tell you why. Because both unhappy means that both are happy. Why? Because if I know that when I'm against someone, if I know that they're unhappy, I actually feel better about that. Right? Psychologically. If I know that they're also unhappy, now I'm not so unhappy. The Rebbe once said it at Fabrengen. He says, why is it that when you come to a Rav and you ask him about the behemoth, about the animal that you just shechted, like is it kosher? Back in the shtetl, is it kosher or not? He says it's not kosher, and you lost $100. You're like, okay. But if you're in a dispute with someone else and the rabbi rules like the other guy, you're like, look, we need a new rabbi. This rabbi's a bum. Well, it's the same $100. Because it's not about losing the money. It's about someone else getting the money. It's about, in the case of the animal, it's just a loss. But in the case of the money, it's a loss and a win by the other guy. That's annoying. But if there's no win for the other guy, if you know that they also lost, all right, I can handle that. We both lost. Okay, I'm okay with that actually. I'm more okay with. Anyway, so what's the bottom line? The bottom line is that in halacha, and I think this is there's the application takeaway, but then there's the core idea takeaway. The core idea takeaway is that ownership is not a convention, but a reality. Ownership means that you have a relationship with it. So the moment you take your what are those called? Hedge clippers. And when you take the clippers and you mentally cut the rope, it floats away. And someone else can take it. Someone else has access to it. As long as you've maintained a mental grip on it, no, I'm going to get it, then that changes the situation. It's all about mindset. All about the power of the mind. Yeah, hold on, Bonnie. Yeah.
I have a statement.
Yeah.
You know, the line that people say something, but I've got a Jewish lawyer.
Yeah.
Which is sometimes I take as like, makes me cringe. But I also, if you have someone who has studied Jewish text and becomes a lawyer afterwards, they have all of this
information,
logic, or just a different way.
A framework, yeah.
And, it's very interesting how they can use that in actual.
100%. 100%. I have friends who I went through yeshiva with. We studied these Gemaras together. Then they went to law school, and they were able to accelerate like much more quickly through it because there's a legal background. There's a legal background. There's a conceptual background. A lot of it feeds in. I've never been to law schools. I can't say myself exactly how that applies, but definitely there is a connection there. All right, so this closes out today's class. So what's the moral of the story? The moral of the story is that mindset counts. Mindset counts. In our own lives, we want to take a positive lesson. Let's be positive and let's be hopeful and let's be caring and loving, because all of these areas of mindset can help us make a difference in the world. So gesund. Not only do actions matter, not only do words matter, but even thoughts matter, as we saw today in actual life. Thank you very much for joining me today Thank you for lesson number 1. Next week, a man, listen to this case, a man in the Holocaust tells the Nazis where his brother's money is hidden to save his life. And after the war, his brother sues him for the money. Next week. He was saving his life. It was a good cause. No, to save his own life. To save his own life. He pointed out where his brother's treasures were buried. Now the brother says, are you kidding me? You could have given them your own money. Give that back to me. Next week, same bad time, same bad channel. We'll see you then. Yeah.
Interesting question. You know what the answer is? Still being with a woman.
Bye, Karen. Good to see you.
Still being with a woman.
Yeah.
The
art, yeah.
Now, it's a fact that artwork, which was stolen by the Nazis and recovered, has a higher value.
Interesting.
Which does not.
Interesting.
The question is,
that makes it more.
Who gets that appreciation? That That was my question.
It's a great question. I don't know. That's a really good question. You're talking about in the kind of like in the hybrid, in the compromise.
He's hard, yeah, he's still well enough. That makes it tough.
And she not only saved, she saved the life of her project all the way down the line.
Take
That
care.
makes it pretty bad.
Thank you. Thank you, thank you, thank you.
A friend of mine's car was stolen.
Yeah.
3 days later, the police said they found the car, come pick it up. He picked it up, opened up the trunk. There was a bag full of golf clubs in there. Does he have any obligation to try to find the owner?
Or did they give up hope? So good. That's a good question. That's a great question.
Thank you.
Pleasure.
So what do I do? Just go in and sign?
Yeah, you can do it online. Yeah.
Same thing.
Yeah, perfect. Good. Always great to see you.
No, it's I find it, not sure what the right word is, but
Hopefully.